It is the admission of insufficient evidence by ICC prosecutor Fatou Bensouda to try President Kenyatta at the ICC that has triggered questions from both the political class and legal minds. Bensouda wants the trial deferred to May from the February 5th next year to give her more time to gather evidence on whether she can sustain a case against President Kenyatta. She told the trial chamber the additional 3 months would enable the prosecution to, quote, undertake additional investigative steps, including those previously not open to the prosecution, to determine whether a case can be presented to the chamber that establishes the accused's guilt beyond reasonable doubt.
And there will be those who make this argument. You could see this as a product of the political pressure that the ICC has come under from the AU and the Kenyan government. It may be seen, if this view is correct, as a tactical political retreat on the part of the office of the prosecutor to avoid a confrontation with Kenya and with the Kenyan president.
The reason why for a long time we have been saying that the president should not go to that trial was because you cannot get justice from an unjust process. And it is important that they actually review and look at the evidence in both cases, because the threshold is the same, and also the evidence was procured at the same time by the same intermediaries.
The victim's legal representative, Fergal Gaynor, says the victims will need an explanation as to why, after all these years, the prosecutor has not yet collected sufficient documentary evidence, which combined with testimonial evidence would be sufficient to satisfy the evidentiary standards required at trial. He adds the victims will want to know what obstacles the prosecution has encountered in its efforts to obtain that evidence and what measures the prosecution has taken in order to deal with those obstacles. Bensouda has further proposed that the court discusses this matter at length at a status conference on the 27th of January next year.
We want to urge the prosecutor to stop and reflect on the ongoing trial of the deputy president, because the witnesses that she has used so far have been proven by the defense to be liars.
Will they seize the opportunity now to make similar arguments, saying that in fact, in our view, the witnesses who have already come before court are not really giving evidence that can actually sustain a conviction. Therefore, you should take the same road.
P12, a key witness Bensouda was to rely on in her case against Kenyatta, has as such been withdrawn. This witness had alleged he attended a meeting at State House on 30th December 2007 in which he purports Kenyatta participated in organizing and funding the violence that later unfolded. He was to, however, deny attending any such meeting, admitting he had lied to the prosecution, the result of which has a substantial effect on the prosecution's case. Another prosecution witness, a P11, withdrew from the case last month. As such, Bensouda says his withdrawal undermines the prosecution case, removing evidence regarding the intermediaries who allegedly oversaw the attacks on the accused's behalf. Jacky Maribe, Citizen Weekend.